Time to say good afternoon to Chris Dimakos, our CJAD 800 legal contributor. And Chris, I said before we came on, just before the news, I don't think I've ever heard of this before, the story you're going to talk about, but that's what you wrote. This is a story that you've heard. An employer warning an employee to stop coming in early. You made this up, right?
No, this is an actual judgment that was rendered here in Canada.
No.
Yeah.
All right, let's hear the story. This is great.
So you have an employee that decides to show up every day about 45 minutes early. And the reason for that being, I guess it's just a logistics thing, travel, traffic. They want to get ahead. So they show up early every day. They log on to their computer, and they start working early every single day. And the employer says, listen, I don't want you to come in early anymore because we've had issues in the past where some employees were saying that they worked overtime. We don't want to have that. You start at 9 o'clock. Please come into work at 9. If you're going to hang around, have a coffee in the parking lot, but please do not log on to your computer early and start doing work. Well, the employees didn't listen to those directives and thought, whatever. I mean, I can come in early if I want to come in early. They can't fire me for coming in early. And the employer gave warnings, written warnings. The employee kept coming in early, and finally they fired the employee.
What?
Fired him. And he filed a complaint, went to the tribunal, and the court sided with the employer and said, look, you were warned several times. They did not want to have issues with overtime. You have to listen to your employer when it comes to directives that are clear, and they told you, stop or there's going to be consequences, and you ignored them.
Hold on. Okay, but when you said overtime, I did not assume when you first said that this employee was coming in a half an hour early that he was doing this and claiming overtime. He just decided to show up early.
He wasn't claiming overtime. He just decided to show up early. But the employer had issues, especially with there's new laws and regulations about when employers can be contacted, employees on the weekend and nights and early. So the employer's like, we want to have a very, very clear line in the sand here. You start work when you start work. You finish work when you finish work. It's 9 to 5. We don't want to have to be on the hook afterwards because someone says, oh, by the way, I've been working overtime these last couple of months, and you never paid me for it. They didn't want that situation.
Yeah, but he never asked for that situation.
No,
so that's
never
hypothetical.
asked for it, but it has happened where an employee after the fact says, oh, by the way, you didn't pay me for my overtime. The employer says, I never asked you to work overtime.
Oh, I see.
Yeah, well, I did.
Okay.
Well, I did. So, and that's what they wanted to avoid. And what's very interesting about the court is the court had to look at what happens when an employee disagrees with an employer. Are they allowed to disagree with an employer? And what happens when it becomes insubordination, in which case you get fired and there's no severance whatsoever. You lost all of your entitlement to a severance package because you were fired with cause. And that's the case right here. And the courts were very clear about this. Listen, you're allowed to disagree with your employer. You're allowed to have conversations with them and maybe disagree. But when it comes to clear directives, when they put not just ask you to do something, they tell you if you continue to do this, there's going to be consequences, and you continue to do that, well, then you can find yourself without a job, and you can find yourself without any type of parting package if they let you go. So what's important for everyone to retain from this is, understand the difference between having a conversation where you disagree with your employer and committing what is called, from a legal term, insubordination, where you explicitly go against clear instructions or orders from your employer.
Are you telling me, Chris, in this case as well, that this employee lost whatever severance they would have accumulated as well?
Right. They left. They got fired with nothing. They got fired with nothing because whenever you get let go, and most of them are without cause, or the employer doesn't feel comfortable enough arguing that there was just cause, they provide for severance. But it's not an automatic. If the employer, if somebody shows up to work intoxicated, commits a very, very wrongful act, whether it's theft or whatever the case may be, there are cases where you can get fired without any severance whatsoever, which is another word for notice. And in this case, because the employee had the opportunity to change, and because they were clearly warned in writing and they were told about the possible sanctions if they continued to ignore the instructions, and they did so, they were left with nothing. And it seems ridiculous when you look at the facts of someone just coming into work early to avoid traffic. But there has to be a line in the sand where the law says, look, if you're getting these clear instructions from your employer, you can't just ignore them. You have to work with what your employer. There is that element of subordination that you have to maintain as an employee. And in this case, there was a breach there, which basically stripped this employee of all their severance and notice.
Wouldn't it? I was trying to play peacemaker here for some reason. Wouldn't it have made more sense for this employee who was coming in early to have a discussion with let's say his employer, and say, look, I'm going to be coming early. Here's why I'm doing it. And I'm not going to be asking for compensation here. Right.
I believe you're absolutely right about that. And I believe that happens often. But I think sometimes when there are personality conflicts, and sometimes when an employer can hang their so-called hat on a hook that they see available to them, they might just have taken that opportunity. So I agree with you, Aaron. I think in most cases, a simple conversation would have rectified this situation. And maybe you could have said, hey, you know what? If you're going to work an extra 45 minutes in the morning, maybe we can cut you some slack and you can leave early. And that usually gets taken care of with a conversation. But I don't think that for some reason it looks like the personalities here conflicted more so than the judgment allowed me to proceed. But you can read between the lines. There probably was some conflict there from a personality perspective from upper management and this employee.
By the way, so you said there was a court ruling, then a judgment in this particular case. For whatever reason, let's assume you wanted to take this to, a higher court. Could you? I mean, this is one judge's decision in this particular case. If you were to lay out the facts, Chris, and say, look, I never expected compensation. I didn't ask for compensation. This is a hypothetical. They thought I might ask for compensation. Therefore, it's not fair. Is this over? Could you go somewhere else with
right.
this?
So, yeah, and that's such a good question because when you look at the ruling, what the ruling was based on, it wasn't based on the facts of what brought them to the table. It was a question of whether or not what the employee was doing was insubordination. That was a legal question. So it's a great. You just mentioned, it seems so frivolous for an employee to come in 45 minutes early and have them terminated without any severance. It just seems unjust and unfair. Wouldn't you be able to appeal it on that basis? And the answer to that is you probably will not be successful because the question that was put before the court wasn't, was this employee being unreasonable in terms of what he was doing? He didn't steal anything. He didn't physically assault anybody. He just came into work early. Are we gonna allow for this employee to be fired without any notice whatsoever because of that? And the answer is, well, the question we looked at is this insubordination? Did the employee consciously and repeatedly go against clear instructions from the employer? And the answer is yes. Yeah. Even though the actual facts don't seem that serious, the fact that you go against your employer's instructions can be serious, and you could be deprived. So, if they came to see me, I would say you don't have a very strong case to appeal this because you were informed many times and you continued. What would have been a better thing was had he came to see me while this was going on, you could have neutralized that and you could have had an email and you could have conveyed your position to your employer where you're saying, I don't want to go against your instructions, but here's why I'm coming in early. You probably would have had a better chance of neutralizing that legal consequence had you been proactive and addressed it early on instead of just leaving it go.
So for anybody listening, if you're planning on showing up at work early on a consistent basis and think there's, not a problem with that at all, maybe the rule, or I guess the advice here is based on this judgment, have a discussion with your boss because as innocent as it may seem, at the end of the day, this could cost you your job. I'm not sure how often this happens, Chris, because again, I've never seen this before, but that's probably not a bad thing to say or to have that discussion.
No, and you're absolutely right. And the key point is here, if your employer is giving you instructions not to,
right, okay.
This is where you want to take it very seriously.
Yeah, let's say your employer also say, hey, you know what? Don't work too hard because, it's not a good idea. You're going to make everyone else look bad. So right. I can't believe this story, but I get it. I get it. They tell you to do one thing, you choose to do something else, and this is where it ends up. Chris Dimakos, our CJAD 800 legal contributor. Thank you, Chris.
Thanks, Aaron.
I'm Dylan Playfair.
And I'm Tyler Smith.
We're putting loneliness in the penalty box by talking to some of our favorite athletes about the importance of friendship.
This
is bromance.
Bromance is brought to you by Charm Diamond Centers, proudly Canadian owned and operated. Charm has been part of your love stories and bromances for over 50 years.
And you can find Bromance on the iHeartRadio network or wherever you get your podcasts.